This is Building 1301, the headquarters of SolarWinds Corporation in Austin, Texas. Inside, software engineers develop network monitoring tools used by Fortune 500 companies, federal agencies, and critical infrastructure operators across America. The company's flagship product, Orion, is installed on the networks of 18,000 organizations worldwide. What the engineers don't know is that someone has already gained access to their systems, someone who has been watching, waiting, and learning for months. Russian state-sponsored hackers have infiltrated.
It's been a good team working together with Valero. I think they've been very cooperative in adhering to our requests, and we're able to do this time. As you can see, there's a general layout.
The software supply chain, and they're about to pull off what cybersecurity experts will later call the most sophisticated cyber attack in history. December 2020, FireEye, one of America's premier cybersecurity firms, issues an emergency alert. Their internal networks have been compromised. Hackers stole their red team tools, the very software they use to test client defenses. Within days of that announcement, investigators make a disturbing discovery. The breach didn't start at FireEye. It started at SolarWinds. And FireEye wasn't the only victim. The US Treasury Department, the Department of Homeland Security, the State Department, all compromised through the same attack vector. But here's what made this different from every other cyber attack. Of the 18,000 organizations that were exposed, the attackers only activated their malware on approximately 100 high-value targets. This wasn't a ransomware spray and pray operation. This was surgical, selective espionage. And the hackers had achieved something unprecedented. They convinced victims to install the malware themselves by disguising it as a legitimate software update. To understand how this happened, you need to understand how modern enterprise software works. SolarWinds Orion is network management software. IT administrators install it to monitor thousands of servers, routers, and devices across an organization. Orion needs deep access to function properly. It requires administrative privileges, network visibility, and the ability to communicate with every system in an organization's infrastructure. This makes it powerful. It also makes it an ideal target. But here's why the attackers chose SolarWinds specifically. Orion wasn't just installed on networks. It was deployed with administrative-level access across both government agencies and Fortune 500 companies simultaneously. The software's trusted position meant it could communicate with every corner of an organization's infrastructure without raising suspicion. And because Orion updates were deployed on long cycles, sometimes quarterly, an infected update could sit undetected for months while the attackers worked. The attackers didn't just need any software vendor. They needed one with deep trust, pervasive deployment, and long dwell time between updates. SolarWinds Orion checked every box. But there were warning signs. In the years leading up to the attack, SolarWinds had prioritized rapid growth over security investment. Internal security assessments had identified vulnerabilities. A security researcher had even discovered a SolarWinds GitHub repository protected by the password SolarWinds123. Though investigators would later clarify, this was for a legacy development server and not the primary entry point for the Russian hackers. Still, it illustrated a pattern. The company's focus remained on customer-facing features rather than hardening their development infrastructure. This cultural weakness would prove to be a critical vulnerability. The attack didn't begin with a dramatic breach. There was no Hollywood-style hacking montage. Instead, the operation started with reconnaissance. Lots of it. By late 2019, forensic evidence strongly suggests the attackers had obtained extremely high-level privileges, likely domain administrator access in SolarWinds Windows environment. This suggests they either compromised a privileged account directly through targeted spear phishing, or they gained initial access through a local
Linux terrorist tracking system restarted.
lower level account and escalated their privileges. The exact entry point has never been publicly confirmed. Some cybersecurity researchers have theorized the attackers may have exploited SolarWinds' own internet-facing Orion demo server, though this remains unconfirmed. Other theories point to compromised VPN credentials or exploitation of vulnerabilities in external-facing infrastructure. What's certain is that by late 2019, the attackers had achieved the level of access they needed to proceed. Once inside SolarWinds' environment, the attackers moved slowly. They studied the software development process, they identified where Orion updates were built, tested, and digitally signed. They learned the company's internal security protocols. They watched how engineers worked, when systems were monitored, and where gaps in detection existed. This reconnaissance phase lasted months. By September, December 2019, forensic evidence shows the first test code was compiled into the Orion software, the earliest indicator that the attackers were experimenting with the build process. By October 2019, investigators believe the hackers conducted a more deliberate test. They injected benign code into the build process, code that did nothing malicious, code designed simply to see if anyone would notice. No alarms went off. No security teams intervened. The test proved what the attackers had suspected. They could manipulate the software factory line without detection. Now they just needed to wait for the right moment to weaponize it. By December 2019, the hackers had identified their opportunity. SolarWinds used a build server, essentially a software factory line, to compile software updates. This server takes source code written by engineers and converts it into the actual software that customers download and install. If you could compromise the build server, you could inject malicious code directly into the software update itself. The update would be digitally signed with SolarWinds' legitimate certificate. It would pass all security checks, and it would be distributed directly to 18,000 customers through SolarWinds' own trusted update mechanism. The attackers didn't sneak into the building. They became the company that built the building. But the attackers needed a way to inject their code into the build process without manually accessing the build server every time. So they deployed a tool that researchers would later name Sunspot. This injector malware monitored the build server, watching for when engineers compiled the Orion software. The moment a build started, Sunspot would automatically insert the backdoor code into the compilation process. It was an automated infection system, a malware assembly line worker that showed up for every shift. In February 2020, with Sunspot operational, the hackers struck. The injection point was surgical. Sunspot modified a single DLL file, solarwinds.orion.core.businesslayer.dll, adding their backdoor to a legitimate inventory monitoring class called Inventory Manager. This wasn't a crude insertion of obviously malicious code. The malware was carefully woven into existing functions, disguised to look like legitimate error handling routines and background processes. When SolarWinds' automated build system compiled the next Orion update, it unknowingly baked the malware directly into the binary. The build server then applied SolarWinds' legitimate digital signature, the cryptographic stamp that tells the world this software is safe and comes from SolarWinds. The result was a Trojan that every security tool in the world would trust. The infected update was released in March 2020. Here's what made this attack so devastating. The malicious update functioned perfectly.
Small disciplines
IT administrators
needed
installed it
to
expecting routine bug fixes and performance improvements. The Orion software continued working exactly as intended. Network monitoring remained operational. There were no crashes, no obvious errors, no red flags. In the background, something else was happening. The backdoor, codenamed Sunburst by cybersecurity researchers, was quietly establishing connections to attacker-controlled servers. Sunburst was engineered with extraordinary care. It didn't activate immediately. For the first 12 to 14 days after installation, it remained completely dormant, a delay designed to evade sandbox analysis tools that security teams use to test updates. But Sunburst was paranoid by design. Before activating, it performed over 100 checks on the infected system, looking for security tools, analysis programs, virtual machine artifacts, forensic tools, and debuggers. It checked for Wireshark, Process Monitor, TCP View, endpoint detection agents from CrowdStrike and Carbon Black, even signs of VMware or VirtualBox. If it detected anything suggesting it was being watched, it would remain dormant indefinitely. Only on systems that appeared clean, ironically the systems of organizations confident enough in their security to skip intensive testing, would Sunburst proceed. When Sunburst did activate, it operated with surgical precision. It disguised its network traffic to look like legitimate Orion telemetry data. It used domain names that mimicked real Orion infrastructure, including avsvmcloud.com as its primary command and control domain, a clever combination of AVSV referencing Orion's actual cloud services with mcloud to create something plausible.
I mean, it's simple task. Very good.
So clearly see that some stuff is not activated as it should be. Some manager to install the problems when opening and closing tasks.
Empty music folders. Shield act.
Some are true, some aren't. So I would just like for us to do maybe a quarterly report because we've been wondering what's going on. And I met one of your candidates, and thank God you didn't hire it. So you didn't have the greatest candidates. I only met one, and I thought, so there are probably some problems here coming to Corpus Christi too, and we can blame this city for all of our animal problems, but it is the residences. They're the ones that have the animals. It's a cultural problem here, and that is
Dynamark Security recording placement scan. Trim complete. Processed 24. Moved 24 radio transmission files to process.
Period of time that we're talking about when it started, the 29th of
Real
September.
strength does not need to hide behind it. New files sorted. 20. Quarantined 0 empty Dynamark Security folders. LTAS JSON generation complete with Word.
We don't know that. There was also video taken inside the building where he opened fire, and I asked police and the mayor about that today.
So what
Trying to make sure we're correctly referring back to the out of the building. And I'm wondering if that's support
Linux voice control stopped. Terracit Dynamark Security recording placement scan trim complete. Processed 24. Moved 24 radio transmission files to renaming complete. 25. New files sorted. 24. Quarantined 0 empty Dynamark Security folders.
Was conducted in a slow, methodical manner. To maximize safety and visibility, large-scale evidence collection was prioritized during daylight hours
complete
on Sunday,
with worded
while additional investigative work and coordination continued overnight. Evidence collection was completed at approximately 6:30 p.m. on Sunday. At the same time, the collected items were transported to a Southern Nevada Health District facility for temporary temperature
LVC JSON generation complete with multi-word groups.
New files sorted.
You
24 placed in worded folders.
You don't.
Quarantine 0 empty music folders.
Around you. I've been using them pretty much every day.
Hello, my name is Jody Wilmus. I'm product manager for Thermwood's Cut Ready product line.
Linux terrorist tracking
This is the first
system restarted.
in a series of short videos to give you a better understanding of what Cut Ready is all about, what it can do for you, and how it can benefit your business. Before I show you around the machine, though, it's important to know the differences between CNC machines and cut centers. Starting with CNC machines, there are some mandatory requirements and expenses
Hello 1.
Hello 1. Hello.
Trump has been very vocal that he disagrees with the fact he wants lower rates. Also known that President Trump has been very vocal that he disagrees with the fact he wants lower rates. It is not like that. We would very much see that different in President Trump that
Roger that.
Terracit Dynamark Security recording placement. Trim complete. Processed 21. Moved 24 radio transmission files to
of the plugins.
renaming complete. 25 files.
357, repeating 357.
New files sorted.
I'm going to disconnect from the adapter. Now, when we've done that,
Quarantined 0 empty Dynamark Security folder. LTAS JSON generation complete with
of the Congress or of this committee. It's an extraordinary remedy that's usually reserved for situations where witnesses have clearly and willfully defied Congress after extraordinary processes have been exhausted. The majority has not demonstrated that standard so far. I do want to say also that we're in a situation where I don't think that anybody on the Republican or on the Democratic side of this committee is trying to defend former President Clinton. They're trying to find a way to make sure that we're consistent. So the reason we keep hearing the need to have Pam Bondi before this committee is that we're getting ready to bring criminal contempt charges before there's been an investigation. Usually that happens after the investigation. And the notion that somebody is going to come before this committee, Mrs. Maxwell, and take the fifth, I don't care. She's already a convicted criminal. She can't take
Linux terrorist
but we can do the actions we ought to be about, and that is to make sure that both of them are before this committee, and then to make sure also, or to suggest, it's up to you and the ranking member, that that meeting takes place, and those transcripts are made available, and that Mr. Clinton comes before the committee with counsel, so that we then are in a position to move forward. We're taking a big jump here without doing some of the things that we normally do. Now, I'm glad that Ms. Tlaib brought up the matter of victims. She's not here right now, but all of us sat in that room with those victims. It was gut-wrenching, and all of us made a commitment that we would prove that this institution could and would do the right thing. So we're challenged here, Mr. Chairman, and I hope that you and the ranking member can give us a way to proceed here that both of the concerns on both sides are addressed. But if we just move straight as we're going now without an investigation, it begs the question, what happens when the shoe is on the other foot? I yield back.
Gentleman yields back. Ms. Simon's next. Before I recognize her, I just want to add, with respect to the Hillary Clinton subpoena, you all voted for that. This committee voted for that in a bipartisan manner. Her name was on that list. And with respect to Pam Bondi, again, she's testifying in front of Congress in less than 2 weeks. Chair recognizes Ms. Simon.
Thank you, Mr. Chairman. Just a quick comment, and I have a friendly question for my colleague, Ms. Luna. And I'll say a friendly question. I've worked with victims for decades. So few opportunities present themselves for victims to sit face to face with folks who hold power, to beg and plead that everyone who had anything to do with their harm be held to account. So few opportunities. I have been a victim advocate where brilliant young women who have been trafficked across this country have stood in courtrooms and were demanded to
Harassment
testify against their
disguised
traffickers, and
as
they did
science
with such power and grace, in fear that their lives may be taken because of that braveness. And a number of those young women that I witnessed take all that they had to confront their demons. They were murdered because they took a stand. And so when we did stand in front and sit in front of those victims and they gave us their all, I hope that this is not the only opportunity, Mr. Chair, to speak on their behalf. From our president to everyone in those files. Forget all the political games. If these women who are connected with the largest sex trafficking ring in modern day American history cannot get justice, what about the girls in every single state? I mean, it is what it is. That being said, Ms. Luna, you talked briefly about a proposal.
She's not in.
She's out.
That's bogus.
There was a proposal put on the table to rethink
The following
how
is for
we might
information only.
have a conversation
You are
about
writing your day one sentence
or
at a
President
time.
Clinton coming in and having a conversation
with immediate test for communications. This is only a test. Following is an immediate test for communications. This is only a test.
Clear frequency for emergency message. Clear frequency for
this.
Okay. Do any other members seek recognition? Seeing none, we are going to, there's an amendment at the desk. Well, let's Ms. Lee, what purpose do you seek recognition?
I have an amendment at the desk.
Will the clerk distribute the amendment to all members? The clerk will designate the amendment.
An amendment to the amendment in nature of a substitute to the William J. Clinton contempt report as offered by Ms. Lee of Pennsylvania.
Without objection, the amendment is considered as read. I reserve a point of order. The gentlewoman is recognized for 5 minutes to explain her amendment.
Thank you, Mr. Chair. I think that even listening to this debate throughout our hearing today, our markup today, I think it's really clear that at the heart of this effort to release the Epstein files are very real human beings who have experienced unimaginable harm. They have been repeatedly victimized by the indifference of the U.S. government and the injustice that they face. They deserve peace and healing and justice. When my motion to subpoena the Epstein files passed, this committee resolved to get that justice for those survivors. And I thank Chairman Comer for pushing this effort forward by issuing additional subpoenas for the Epstein estate and the banks. And we know that without the full files from the DOJ, that is just not enough. That's why I'm introducing this amendment, which holds Attorney General Pam Bondi in civil contempt for failing to comply with the August 5th subpoena, and I urge my colleagues to support it. And we believe that we should start with civil contempt because we are serious about this investigation. We want these files and we want to hear from them. And we must start there. The Department of Justice needs to be the priority. We can move to non-compliance by anyone else, including Ghislaine Maxwell, after we have received those files. It has been 5 months, and we're still missing over 5 million pages of documents purportedly. The Department of Justice has only released 1% of those files. They have stonewalled this committee since August, and they have
The
failed to
future
provide
belongs
even
to
one
those who
basic
build.
updates. How is that not an insult both to the authority of this committee and the survivors? Without the full files, how can we know who might have legitimate knowledge or who might be culpable?
Peace does
We
not
wouldn't
need
have
to
to
disturb
speculate on the
another.
Clintons or anyone else's involvement if we had all of those files. And to be clear, I'm certainly not opposed to the President and Secretary Clinton being held accountable for violating the subpoena. But the fact that this effort to hold the Clintons in contempt was fast-tracked and is happening before any action against the Justice Department is just evidence that the Republicans on this committee are not taking this investigation seriously. It is an unequal application of law. And again, it is a bit ironic that these contempt resolutions empower the Justice Department to imprison possibly 2 people for defying the exact same subpoena that they themselves are defying. If this committee wants to be taken seriously, we would be addressing all of the bad actors in this investigation, not cherry picking them for political points. The Justice Department needs to be held accountable for their non-compliance and lack of transparency. They have been selectively producing information, shielding powerful people, and obstructing any efforts for oversight. And if we don't hold them accountable, Mr. Chair, we are too. Just this past Friday, Attorney General Bondi asked a New York federal judge to deny an appointment of a special master to monitor the release of the Epstein files. They don't want a neutral third party making sure they follow the law. I think all of us should be questioning what the Justice Department is doing that they don't want the American people to see. We can't just take them at their word that they'll eventually get around to releasing the files. Quite frankly, they have put up the same, if not far less of an action as the Clintons have. What little information they've released so far has either already been made public or has been a mess of just sketchy redactions. A group of survivors sent a letter to the Justice Department's Inspector General complaining that the redactions had been, quote, selective. They pointed out that multiple times the names of alleged abusers appeared to be redacted, yet some survivors' names and identifying information were released. To be clear, the subpoena I moved to secure does not allow for redactions unless it would protect the identity of a survivor or contains child sex abuse materials. They have had plenty of time to work with this committee to protect survivors' identities. This is bigger than one case. It's about rich and powerful people being protected by each
Dynamark
other
Security
and institutions. It's about a system that has enabled Jeffrey Epstein and Ghislaine Maxwell and whoever their co-conspirators are to buy favors and silence from our government. This effort is the one time we could get some real accountability and reclaim the power of this system. Republicans, don't drop the ball by allowing Pam Bondi and the Department of Justice to play us for fools. Mr. Chair, you are setting a precedent that non-compliance with this committee will result in immediate contempt proceedings. So I challenge you and my Republican colleagues to put your money where your mouth is and pass this amendment and holding Pam Bondi in contempt.
Complete.
I yield back.
Generally, back, I'll recognize myself just for amendment. Look, I oppose this amendment, and I hope everyone on the committee opposes this. That's because Attorney General Bondi and the Department of Justice, they have released
24
again, not at the speed
transmission
or pace
files
that any of us want, but they are complying with our subpoena. That is a fact. Oppose your amendment, Ms. Lee, because you amend the criminal to civil. And I think that most of what I'm hearing from my colleagues on the other side of the aisle is everyone wants to hear from the Clintons. They've had an opportunity for 5 months. They will have another opportunity between today's vote and the floor to come in and answer questions. Pam Bondi is coming in front of Congress in less than 2 weeks to answer questions. Your colleague, Ms. Crockett, again, I don't want to speak for Ms. Crockett, but I'm pretty confident Ms. Crockett's going to grill Pam Bondi, right? You agree with me? I would have won that bet.
Is she coming with the facts?
Well, we'll see. I think that's a good. She may.
Quarantine zero empty Dynamark Security.
Now, Chair recognizes Mr. Garcia.
Thank you, Mr. Chairman. I wanted to start by saying I strongly support the amendment proposed by Congresswoman Lee. The House majority keeps saying that they believe that no one is above the law.
JSON generation complete.
Oversight Democrats certainly believe that, but the Attorney General is violating it with impunity in support of a White House cover-up every single day. We want accountability for her failure to comply with our subpoena for the full Epstein files that's been in place since the summer. She fails to comply with the Epstein Files Transparency Act. She fails to comply with the subpoena put in place by Representative Lee and the committee. This is clearly a White House-directed cover-up. Now, over a month after the deadline, only 1% of these files have been released. No explanation has been given for illegal redactions, again in violation of the law. Epstein survivors have reported that their names have appeared in parts of the document that were not redacted. And every day, she continues to withhold files and conceals the truth. She continues to give Ghislaine Maxwell special treatment by moving her to a less secure prison that we all are aware, which is completely shameful. Now, Chairman Comer, you claim, of course, that the Attorney General was complying with our subpoena. I mean, that is absolutely false.
Linux terrorist tracking system restarted.
Since a subpoena in place during the summer is not complying with our subpoena. Now, on August 5th, 2025, this committee issued that subpoena, compelling her to produce documents and communications. That subpoena unambiguously required the Attorney General to do that no later than August 19th of 2025. August 19th, not December, August 19th of 2025. On August 22nd, the DOJ made a single production of approximately 33,000 pages to this committee. All of those documents, however, were already public. The DOJ has made no additional productions to the committee pursuant to the subpoena. The DOJ has failed to provide specific information in response to repeated requests from Democratic oversight staff as to why the DOJ's timetable continues to move and why it's not fulfilled its production or the law. Now, in response to letters from our committee on November 25th, the DOJ transmitted a single letter in response to the committee's inquiries.
Because you called
They claimed that the DOJ was working to comply with the Epstein Files Transparency Act, which now, of course, we know they actually weren't doing because we actually haven't received very much. The letter made no reference to the committee's subpoena, no reference to DOJ's plan for compliance. The corrupt failure to comply with the Epstein Files Transparency Act is not just a crime, it also shows that the Attorney General has made no attempt to actually comply with our subpoena. Now, oversight Republicans might be happy to give President Trump and Pam Bondi a free pass to break the law, but this committee shouldn't do so. This amendment will allow us to go to court to force Pam Bondi to comply with our subpoena and to finally bring the Epstein files to light. I urge adoption, and I yield back.
Gentleman yields back. Any other members seek recognition? Who's next on your side? Lynch, Mr. Lynch from Massachusetts.
Yeah, thank you, Mr. Chairman. Look, as the ranking member pointed out, we've got about 1% of the documents. I take exception to the declaration by the chairman that Pam Bondi and the Department of Justice is actually producing documents, is cooperating. So we've got the 30,000 documents that they sent us in August. It was a dump, and it was largely already made public. It wasn't prepared. I'll give you a comparison. We've got a handful of attorneys that work for the estate of Jeffrey Epstein, and they have given us more in the same amount of time than the Department of Justice has given. And I want to point out that there are 100,000 employees of the Department of Justice. And I know very recently the
strongest signal you can send is one.
The possibility that there could be an 11th-hour deal. Is that person being realistic? Do you think that there could actually be an 11th-hour deal?
You can understand why it would happen.
David, last night, 1838.
And
Dispatcher still do not copy you.
U.S. Attorney for the Southern District of New York has now put a considerable number of people on the case redacting documents, but that was 6 months after he started to do that. Clayton started to do that after.
Maybe they were afraid to face me while I was here, but I'm here now and I'm going to face you. Just to be clear, if you have this job, you should know that any subpoena from another Congress is invalid in the next Congress. It dies with the last Congress. That's minimum information that you should know if you're going to serve in Congress. So just let me inform you of that if you didn't know that. Regarding the so-called subpoena, it is unjust and it is immoral to get a group of your friends together who have a predetermined outcome, put them together in a room and use the recording placement to prevail on your political enemies. The subpoena that was served to me or my counsel was not valid because there was no valid committee serving it. I did not violate any law, and I reject the claims or the appearance that I did.
Trim complete.
The Democrat Party
Process
sought
24.
to, by use of the awesome and
food at the grocery store because they're worried that their very family might get ripped apart.
Just the grand power
It is less safe
of the federal government
when we have roving
Moved
to destroy
24
my
radio
reputation
transmission
as a person
files
who was
to
not charged with anything, was not accused of anything, was not the target of investigation. You wish to dirty me up and bankrupt me so you can get rid of me. It is outrageous, and I have not mentioned that at all, but since you brought it up, I felt it was appropriate at this time to clear my good name. And as the years have gone by, more information has come out to prove what I just said was absolutely accurate.
25.
What happened during that period of time when you were in the majority was you set up a star chamber
24
with predetermined outcomes and then sought to
What you pay
destroy
attention
in
to
any way
grows.
possible your political enemies by fashioning lies and then repeating them over and over again, which you do to this day, which you do to this moment. Now, when I spoke earlier, I didn't mention the subpoena.
Quarantined
I
zero
mentioned the
empty
truth, and that's
Dynamark
what
Security.
this committee should be all about, wherever it comes from and whoever it touches. And I believe that to my soul, which is why I have been on this bandwagon long before you have ever been on it, and much more than you have ever done. Much more than you have ever done, legitimately and sincerely. So I thank the chairman for allowing me this opportunity to set the record straight. And hopefully,
even when the main CPU was shut down,
that won't happen
with
in the
its own
future.
firmware and network
Now,
stack
regarding
and
the
processor,
Clintons,
it
as
can
you know, I
reinstall
offered
your
the
operating
amendment,
system, reset
the
a password,
resolution to bring
or wipe
everybody
a drive
in, attorneys
completely
general from
remotely.
both sides
For
of the
IT
aisle.
departments,
But
it was
with
a
the
game
Clintons in
changer.
particular,
But for
because
everyone
of
else,
their
why
particular
would kill the
knowledge
idea that you could ever
of
fully turn your
Mr.
machine
Jeffrey
off.
Epstein and his
Once Intel
exploits
started, it didn't take
with
long before everyone
underage
else
women.
jumped in.
It is
AMD has
horrific.
one that
As
acts
a
like a
father,
gatekeeper.
as a father of two young daughters, I would just say that the perpetrators of whatever happened ought to be thankful that their fathers don't know about it. But I sure hope that they do know soon. And I sure hope that there is justice for all the victims and
Linux
that we don't
terrorist
seek to
tracking
destroy the
system
lives
restarted.
of those uninvolved for political purposes, which is what, quite honestly, this whole theater, this whole charade has been about. This should have been easy. Is Mr. Clinton an American citizen? We appreciate that he was the president, but according to his wife, he's not above the law, and neither is she. This is a lawful subpoena with plenty of time. The committee has been, and the chairman has been more than generous trying to work it out. But it's pretty obvious to anybody with eyes in their head that the Clintons feel like they're above the law and they're going to get special treatment, as Secretary Clinton did the last time she was subpoenaed. I'll remind everybody that she worked out a deal to come in with her so-called attorney, but was her aide behind closed doors on a Saturday without any transcript. That's where we're headed. I'll yield the balance of my time to the gentlelady from Colorado if she wants it.
Thank you, Mr. Perry. I just think that all of this is rich. I mean, we have every Democrat here just with their typical talking points, claiming they want to hold the Clintons accountable and hear from them. So I think it's time we move on and get to the actual point of this. We had the Clintons defy a lawful subpoena, and that is what we are here to discuss. But Democrats want to bring up anything but that. And if this continues, I'm going to call the question. So continue with your Clintons and how you are going to protect them or defend them, or I'm going to call the question, we're going to have the vote and end all of this nonsense rhetoric that's going on. Mr. Chairman, I yield.
Gentlelady yields back. Chair recognizes Ms. Stansberry's next on the list, I think. No? Okay. Frost, who's next? I just go by what the ranking member wants.
What's on the list? No, you can go ahead.
So who's next?
Mr. Frost.
Frost from Florida.
I just want to speak in support of this amendment that has been put forth by Representative Lee. Look, at the end of the day, the United States Congress voted damn near unanimously. One member of Congress voted against releasing the Epstein files, happens to be a Republican on this committee, but damn near unanimously we said we want the files. Months before that, in the subcommittee, in a subcommittee on this committee, we said we issued a subpoena for the files as well. They have failed to comply with the law, not just on one law that we passed, but also on a lawful subpoena that this committee put forth. And so I just want to speak in support of Representative Lee's motion here, an amendment here, because we have to go at this everywhere. We want to hear from everyone. We want to hear from the former president. We want to hear from anyone who's implicated. We want to hear from anyone who has information that might help us get justice for the victims. But it is obvious that my Republican colleagues are doing anything they can to play defense for the administration. 1% of documents is unacceptable. 1% of documents is unacceptable when you've had months and months and months since June or July of last year to produce these documents when we sent a lawful subpoena to the Department of Justice. 1% of documents is unacceptable for a bill passed by the United States Congress that they are in violation of. They're breaking the law right now as we speak. And all we're asking for is accountability here for everyone. And so this amendment, I think, is very simple. I know the chairman keeps bringing up the fact that Pam Bondi is going to come to the Judiciary Committee. The Judiciary Committee is not the committee that is leading the investigation on this. We are the Oversight Committee. And so she can go over to the Judiciary Committee all she wants, like she, by the way, is supposed to, like every other attorney general has in the history of this country, shows up before the Judiciary Committee at least once a year or once in Congress to talk about a lot of different business. But we have a very specific thing we need to talk with her about. And it is talking with her about the fact that she is breaking the law and that the administration is obviously slow rolling, putting forth the Epstein files. And I do not buy this thing that, oh, well, they're taking their time to redact it and this and that. We all know that's a load of BS. We all know that that is a talking point that perhaps the administration gave some of my colleagues that they are just repeating over and over and over again. But when you have the entire Department of Justice or a lot of people working on this, you should be able to produce documents in a much faster way. And the law was clear. And by the way, it's the law that we all voted on. So if you thought that the timetable was unfair, you should have voted no. But you voted yes. We all voted yes, except one. And so I think this is a very sensible amendment that everyone should vote yes on, because it is important that we have accountability across the board. I will yield. I'll yield the balance of my time to the ranking member.
Thank you. Thank you again, Mr. Frost. Just to conclude, we obviously have and support Representative Lee's amendment. We think it's important. It's important to get Pam Bondi to actually produce the files. And it's certainly important to move this debate forward. And so I just again want to reiterate and reinforce our support as we wrap up this debate on this amendment. And so thank you, Mr. Coomer.
Thank you. We have one more speaking request on our side. That's Mr. Biggs from Arizona.
Thank you, Mr. Chairman. And turns out apparently I was mentioned as well. When I was conducting that hearing that on Minnesota fraud, another fraud that the Democrats were so interested in that only 2 of them bothered to show up. That was interesting. Well, so let's talk about the illicit subpoenas, because I think some of my colleagues may not remember this, but the resolution that we all passed out of here to install the J6 committee gave to then Minority Leader Kevin McCarthy specific authority to name the members from the Republican side that would sit on the J6 committee. So he named them.
I do my shopping. I do.
But Speaker Pelosi didn't like those guys.
I run errands.
So she said, no, they can't be on the committee. So she booted them and replaced them with people that she felt would be more amenable to accomplish the desired political outcome that she wanted the J6 committee to have. And that was, so she put 2 individuals, you will remember Liz Cheney and Al Kinzinger on there, having removed,
that sounds really
and no other Republicans were on there. And so not only did she violate the resolution, but the resolution all called for a certain number to be on there, and there were not that number. So the committee itself was illicit. It was not a standing committee. like this is, where you have jurisdictional authorities. That committee, by that point, was no longer a committee. It was an effort to railroad people, including myself. And things have been said about me repeatedly that have been debunked. Everything's been debunked that was said about me. But here we have it today, and Mr. Perry was right. This was designed to go after certain specific people. I'm still not quite sure why I was one, but I was one. And bringing it up today is actually kind of an abhorrent tactic, because it was an illicit committee, didn't have authority to issue an illicit subpoena, whereas this committee issued a legitimate subpoena. Not only did it provide the subpoena, but it actually worked for months trying to get the Clintons and accommodate their schedule, including continuing this at least once so the Clintons would find it more convenient to come and respond to the deposition. Leaving all other deflection aside, if you really want the Clintons to come in and answer these questions, then this would be the appropriate time to vote to hold them in contempt. And with that, Mr. Chairman, I'll yield back to you.
Gentleman yields back. The question is now on the amendment offered by Ms. Lee from Pennsylvania.
Mr. Chairman.
Oh, okay.
If I might,
go ahead.
So that we know exactly what we're doing here, because this has gone way off of where we started with Ms. Lee's amendment. So that members of the committee know this resolves
Dynamark
itself that
Security
the Committee on
recording
Oversight and
placement.
Government Reform shall initiate judicial proceedings in any federal court of competent jurisdiction on behalf of the Committee on Oversight and Government Reform to seek declaratory judgments affirming the duty of Patricia or Pamela J. Bondi, Attorney General of the United States, to comply with the subpoena duly issued to her by the Chairman of the Committee on Oversight and Government Reform as a part of investigating and the investigation
complete.
into federal government's enforcement of
Process
sex
24.
trafficking law, generally and specifically its hand of the investigation and prosecution of Jeffrey Epstein and Ghislaine Maxwell. How we vote on this will be very telling. I support this amendment. I would urge other members of the committee to do so also, if we are serious about equal practice and holding everyone accountable. I yield back, sir.
Gentleman yields back. The question is now on the amendment offered by Ms. Lee from Pennsylvania. All those in favor of the Lee amendment signify by saying aye.
Aye.
All those opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not.
Recorded vote, please, sir.
A recorded vote is ordered as previously
Remaining
announced. Further
complete.
proceedings on the question will be postponed.
25 filed.
For what?
Mr. Chair, I have an amendment at the desk.
New files sorted.
The clerk will distribute the amendment to all members. The clerk will designate the amendment.
Amendment to the amendment in the nature of a substitute to the William J. Clinton contempt report is offered by Mr. Min of California.
Without objection, the amendment is considered as read.
Police
I reserve
searching
a
every
point
morning,
of
Randy,
order. Recognized for 5 minutes to explain his amendment.
Chair Comer, I motion to amend your amendment in the nature of a substitute to authorize the House Oversight Committee to do three things. First, pursue federal court action to enforce a subpoena against former President Bill Clinton related to the sex trafficking investigation. Two, require the committee to report back any resulting litigation. And three, direct the House General Counsel to represent the committee with the Speaker's approval. Now, I have, as mentioned previously, spent my career trying to enforce the rule of law. I started as an SEC enforcement attorney, went on to become a law professor. I very strongly believe in the rule of law. But the rule of law is not just about not having anyone above the law. It is also about not targeting people simply because you don't like them, or because they're in a different political party, or because they've done things you don't particularly care for. Going after an individual uniquely because of how they're positioned is also a gross violation of our powers and of the rule of law. And if you look at the precedent of how Congress has operated, we have three inherent powers when it comes to contempt. Inherent contempt, civil enforcement, and criminal contempt. Now, since we initiated criminal contempt
Linux
back in the
terrorist tracking
1930s,
system
we have
restarted.
rarely, if ever, used criminal contempt as a charge, and we have almost never leapt from civil enforcement to criminal contempt. The decision here to go from civil enforcement and to ignore that step, jumping to criminal contempt, is, in my view, a gross imposition, a gross abuse of power on our part. It is also counterproductive because if we launch criminal contempt proceedings, I think my colleague Mr. Biggs pointed out that we want the Clintons to testify. If we launch criminal contempt proceedings, we will not hear from the Clintons. That is a fact. They will be tied up in court. We have no guarantee that they will ever testify before this committee. Civil enforcement will achieve the goal we want of getting the Clintons out here before this committee. Now, I just think this is problematic. We talked earlier, Mr. Comer, and I still have not heard you to this point in time say anything about the Clintons defying the subpoena. I've heard you say obfuscate, delay, drag their feet. We've had 5 months. But at no point in time do they say we're not complying with the subpoena. And to me, civil enforcement is an appropriate intermediate step. It makes sense because it allows a court to step in, secure compliance with the committee's subpoena in a nonpartisan, orderly way that follows the rule of law. Court would be empowered to impose fines and actual imprisonment if the individual or entity refuses to comply with us. If we break from precedent, this is going to start potentially a chain reaction of partisan warfare with criminal charges. That is not a road I believe we want to go down in this committee or in this Congress. I think civil contempt will achieve our goals, and it will do so in a way that is consistent with the rule of law. With that, I yield back.
Gentleman yields back. I'll recognize myself for a few minutes. The committee's consulted with the House Office of General Counsel as well as committee counsel, who have expressed significant concern with shifting from criminal contempt to civil contempt because it would likely result in extended litigation that would go beyond this term. As Mr. Perry said, a subpoena is only good for a congressional term. He is already 5 months past his subpoena. The Clintons have lawyered up. There's no question in my mind
There is no victory
that if
in
we do
making
this, they
someone
will
flinch.
ride this out and hope that the House flips and that you all are in control and you all just let them get by without answering any questions, which I think is terrible. So I cannot support this amendment. I ask my colleagues to oppose this amendment. Chair recognizes
20 placed in weighted folders.
I want to support the amendment motion. I just want to reiterate something I think all oversight Dems have said today, is that we all want to hear from President Clinton. We all want questions answered from President Clinton. I don't think one member of this committee has stated anything differently. And this amendment is a way for us to secure compliance without immediately moving to criminal contempt while they have been trying to negotiate answering our questions. We can continue to let the legal process play out. Both the integrity of our investigation as a whole is critical as we move forward. This is an opportunity for us to get our questions answered from President Clinton. We will do that without empowering a Department of Justice that, quite frankly, has been corrupt and untrustworthy for many, many months. We should continue to negotiate and work through an established process. Clearly, there's interest to negotiate from the Clinton side. Let's hear from President Clinton. Let's support this motion. I yield back.
If I may, with all due respect, if you want to hear from President Clinton, have him come in for the deposition. They've had 5 months to do that. For whatever reason, been unsuccessful. There's 2 more weeks before this will be voted on in full house. We will hear from Bondi in between, and we will go from there. We expect to hear from Bill Clinton. He's not above the law. Mr. Walker, Charles,
Thank you, Mr. Chairman. A couple of points. One, it seems to me like we made some progress in the negotiation to talk to President Clinton here today. You have acknowledged you and your team are no longer going to demand to be able to ask questions not related to Epstein. The Clintons have agreed to transcription of that conversation. So you could go to New York and talk to President Clinton on the date that you all set. That's ready to go. We've heard from Ms. Luna that it would be a bad look for you and the ranking member to have to drive to New York. They got airports there. You all could take a flight and go to New York and have the conversation. That would move our investigation forward. I'm supporting Mr. Men's amendment in the nature of a substitute, and you know, I'll share. I was a staff member for a member of this committee for more than a decade throughout the Obama administration, multiple chairmen of the committee, and time after time after time, Republicans who chaired the committee, Democrats who chaired the committee, negotiated with members of the administration or private individuals who they wanted to have come before the committee, negotiated the terms. Not once did I see this kind of leap to criminal contempt. It is not consistent with the way that this committee has operated. It is not necessary. Mr. Men's amendment, or you and the ranking member going to New York and having the transcribed under oath conversation with President Clinton would move our investigation forward. Either of those are better options than pursuing criminal contempt, which would not get us a conversation with President Clinton, would not move our investigation forward, and would not get the survivors the transparency that they're demanding. Thank you, Mr. Chairman.
If I may, Mr. Walker, to reply to that, one reason that your counteroffers today don't hold a lot of weight with me is the fact that we never demanded to their attorneys that we ask questions outside the realm of the Epstein investigation. That was never a thing. They have just made that up. So their dishonesty, you know, we've already admitted one lie when they said this wasn't a lawful subpoena. That was in the letter from Bill Clinton and Hillary Clinton to me. They said this is not a lawful subpoena. It is a lawful subpoena. Does anybody disagree with that? It is a lawful subpoena. So number two, we never asked to ask questions outside of this. And I'll give you an example. When we were negotiating with Hunter Biden's attorneys, or Judiciary was negotiating, we agreed when Hunter Biden came in to talk about the Biden influence peddling and the money that they were receiving from foreign countries, we wouldn't ask about the stuff on the laptop. We wouldn't ask about the stuff in the suspicious activity reports about human trafficking and other things with Hunter Biden. We only asked about the influence peddling, which was what the investigation was. And it's been the same with the Clintons. So if their attorneys are trying to spin out with the media that we wanted to talk about Monica Lewinsky or anything else, that is not true. All we want to talk about is Epstein. That has always been the deal. And for them to say otherwise is a complete 100% lie by the Clinton attorneys.
Well, I'm glad to hear that, Mr. Chairman, and I'm glad that the Clintons have agreed to have the conversation transcribed. So it seems to me that the only remaining barrier of the barriers you have identified is you don't want to go to New York. And from my view, this investigation
I'm going to New York
is important enough.
weekend. That's not a barrier.
Go to the moon. Let's have the conversation. You can do it.
Chair recognizes
Terracid Dynamark Security recording placement.
Ms. Stansbury.
Thank you. Honestly, I just want to get some clarification because I've heard so many different things here this morning. So, Mr. Chairman, you just said you're willing to go to New York. In fact, you're going to New York this weekend. Is that correct?
The committee has released the emails, so
No,
you
I'm just
can
asking
see
you,
the communication
I'm not
between
trying
the
to be
staff.
difficult. I really just want to understand. Are you willing to go to New York to conduct this
Trim
interview and
complete.
deposition?
With the committee, with the
Process.
staff, it's not going to just be. We have negotiated this for 5 months, Ms. Stansbury.
No, I'm just asking simple
And you're
questions.
all
So
are
the
speaking,
question-
and they've had 5
So
months.
is the answer a yes? It sounds like it's a
Moved
yes.
24
My other
radio
question
transmit.
for you is, so it's my understanding that you guys have received both correspondence by phone, email, and from a written letter from the attorneys from the Clintons offering to do this on the record with you, with the staff, with the attorneys. Is that correct?
I wasn't paying attention to your question.
Okay, we're here pursuant to a motion you brought for contempt, and the claim is that you have made reasonable accommodations.
Renaming
And
complete.
that they have not
25
been
files.
responsive. But they have transmitted correspondence to all of the
Quarantine
members of the
0
committee, including
empty
yourself,
folder files
and all of
sorted.
the members. Basically, including a letter from their attorneys stating that they have offered by phone, that they have offered by email, and they have offered in a written letter from both themselves and the attorneys to meet with you on the record with the staff to give sworn statements. Is that correct?
We
Quarantined
have
zero
negotiated
Dynamark
for 5
Security
You all
folder.
are trying to create a false narrative. You've had 5 months. You should have gotten to the Clintons before the contempt vote.
All I'm asking you is if that's true.
And if they weren't losing public opinion, Ms. Stansbury,
generation complete
they
with
would be
worded
define this now. That's the only reason there's negotiations at the last minute.
But Mr. Chairman, I'm just asking
They don't get to
if
make
those
the
are
rules. We
facts.
make the rules. The chairman of the committee, we make the rules.
But Mr. Chairman, is that the fact? That's all I'm asking. Is that factual? Just to be clear for the public, his staff are advising the chairman to not answer that question. Okay.
No, the staff said they couldn't understand what the hell you were saying because you've blabbered for 3 minutes, but go ahead.
Okay, Mr. Chairman, let me say it again. Is it true that the Clintons and their attorneys have had multiple conversations with you via phone, via email, and via written correspondence offering to give sworn statements on the record to you and the staff? Just a yes or no.
The Clintons said that we could take notes, Mr. Garcia and I. The committee would like to ask questions as well.
Are you not in receipt
Linux
of a
voice
letter
control
postmarked
stopped.
from their attorneys yesterday saying that they would
Linux
give
terrorist
sworn
tracking
statements
system
under oath?
restarted.
That's not a record.
Sworn, that's not a record.
You're not in possession of the letter that their attorneys sent yesterday to the entire committee.
What their letter is stating isn't what you're stating.
Okay, well, I'm not going to read the letter. We'll make sure it's available to the public.
Although I'm sure
But
they'll
in
make
any
sure
case-
anything's available to the public. The problem is they've not been truthful, and
But Mr. Chairman, the legal standard for contempt is non-cooperation. And so my question to you is, are you making reasonable accommodations? Are you cooperating? Are you in correspondence with them? And this is in direct relation to the motion that was made now for an amendment that essentially would use our civil compliance code in order to get full compliance from the committee. And you're saying you're opposed to it because they haven't complied. But I have not heard you lay out the case for compliance. So why would you oppose civil compliance?
Ms. Stansbury, we've been negotiating for 5 months. In the meantime, every other person has complied with the subpoena that we've
That's not the legal standard for the court, Mr. Chairman.
que es la FBI.gov, la raya de atrás,
Well,
Brown
I
University.
see we have a lot of armchair lawyers here. I am not one. But Mr. Min, I do support your amendment. And I think that while the chairman refused to answer questions on the record, I think we established that there has been ongoing correspondence and that it does not meet the standard.
Ms. Simons recognized.
I would like to yield my time to the ranking member.
Thank you. I just want to clarify 2 things. The first is in the comments, I know, Mr. Chairman, you just discussed about not going beyond the scope of the Epstein investigation with questions. To be clear, though, during the Bill Barr, that you were not interested in, during the Bill Barr deposition, you did go beyond the scope of the Epstein questions. You asked questions about Russia and a bunch of other things. And so that has been that testimony was public. That has been a pattern that has been in the public realm. And so the reason the Clintons have pushed back on that is because you actually have gone beyond the scope of the Epstein investigation in depositions on this investigation with folks you have subpoenaed. I just want to be clear about that. Because you
At the time, I didn't know how much they sucked. I do now.
They suck bigly.
Yeah.
I can use that word.
And I said to them,
Hours on dispatch.
recent kernel, recent driver. You should be able to run that on any computer without any problem. So to conclude on Cosmix and CompOS.
Well, thank you for being the landowners, because that does mean a lot. It's no different than when you drill a whole well on your property. It's negotiating, and you need to get to know who they are, because they're going to be there and you're going to be working together. So thanks for doing that. I think this is a dream team. I'm really excited about Hanson Engineering and Pete Dawson Tura together, because if we can get this done, it's going to be done with this team.
I don't have a product piece, so we'll just say for the manual install of Windows App Support, and therefore now hoping I click here, it will install Adobe Audition. Do we want to run Setup XE? Yes, we do. Let's see what happens. Very exciting. Wine has come up, so hopefully...
There is no IFRS that you can show us 10.
At 642, there's a Zachary Hall. In-house.
No, that the major technical have cozied up to it, not part by the street with
rescue vehicles from all over the state and knew something was clearly pretty serious.
And then you see the FBI out here.
I always say, Bill Vacancy, and that's still a title out there, first president of the U.S. Brown.
And so this guy, Roy Welch in Dallas, put an antenna up and pointed where the satellite was. And on February 11th, 1958, let's see if this works. It does not. In any case, it just sounds like that warbling sound that you heard when I tuned in that particular thing. That's one of those things. The cosmic ray.
No, go ahead. Two, four, putting up.
of subsidies expiring or not is not working for people. You've got to present a bigger vision, and I think the pops on both your houses are going to come up in the
Carlos, let me get your take. In talking to a White House official, I was told, look, don't rule out the possibility that there could be an 11th hour deal. Is that person being realistic? Do you think that there could actually be an 11th hour deal here?
Another one. Out.
Charlie, 230 case number.
Anyway, this segment of the video is called Applications. And if you want to use your computer to browse the web, access email, run office programs, view and edit photos, and play music and video, then Zorin OS Core may well have everything.
Terrace at Dynamark Security recording placement. Trim complete. Processed 20.
Numbers on the score again, talking about 2 meters lower on that.
Moved 24 radio transmission. Renaming complete. 25. New files sorted. Quarantined 0 empty Dynamark. LTAS JSON generation. I've shared most of my thoughts already. Terrorists talking to Heath House workflow complete with fixed JSON.
Another paradox lies in the concept of the arrow of time. Where the universe moves inexorably forward in time, White holes suggest a scenario in which time can flow backward, at least from a certain point of view. This concept breaks not only our understanding of time, but also the very nature of causality in the universe. Let us summarize the characteristics of white holes, their event horizons, the expulsion of matter, the constant time zero.
You keep coming back? I like that. One more time.
You have all that paper to go through when you walk in.
Remaining complete. 21 files remain.
This will save some cost with all the printing that we've been doing.
Silence can be medicine. Don't turn Terracit Dynamark Security recording placement. Trim complete. Processed 21. Moved 24 radio transmission files to
amendment. I would urge other members of the committee to do so also, if we are serious about equal practice and holding everyone accountable. I yield back, sir.
Renaming complete.
South of Seattle and Ording.
25.
The gentleman yields back. 75,000 people to be ready to evacuate.
The question is now on the amendment offered
New
by
files
from
sorted.
Pennsylvania. All those in favor of the Lee amendment signify by saying aye.
Aye.
All those opposed.
Well, a lot of folks are going to be staying indoors. A lot of folks that we've spoken to say they're just going to bundle up if they're heading out, because here in Buffalo, temperatures are set to plummet tonight with wind chills in the single digits. So the
Quarantined 0 empty Dynamark Security folder.
Arthritic fingers, Ruth Falk, always doing the most for our community. She's at home
LTAS
doing the most that she
JSON
can. She can't
generation
stand
complete
very
with
long,
wording.
and she can barely sew now, and she can barely see. But every year I can depend on Ruth Falk showing up. Every year I can depend on a church like St. Paul's
Rundown on fencing.
donating over
Sounds kind of crazy.
3,400
You don't think
diapers
about
this event.
permits and sizes and requirements.
some were going for over 30 years.
Depending on where you live, keep in mind that you might need a permit and there might be some requirements on
Linux terrorist tracking system restarted. Terracit Dynamark Security recording placement scan complete. Trim complete. Processed 24. Moved 24 radio transmission files to process. Renaming complete. 25 files. New files sorted. 20. Quarantined 0 empty Dynamark Security folders. dhsCCPD generation complete with worded.
A little bit low there, off to the left. The spotter stopped, so hopefully they can make the corrections and make impact on that target.
Well, a little closer, but not quite good enough.
Yeah, they're dialing in here. You should have a good chance to make impact now.
Well, a little closer, but not quite good enough.
Yeah, they're dialing in here. You should have a good chance to make impact now. They've saw 2 shots.
Yep, he got it. Success on target number 2. So 4 hits on target 1. It took
Between the thought and the action.
The third number 2. So 4 hits on target 1.
Linux terrorist tracking system restarted. Dynamark Security recording placement scan. Trim complete. Processed 21. Moved 24 radio transmission files to renaming complete. 25. New files sorted.
Right now,
24 placed.
On a ship they'll be heading to ultimately New York, and then a decision will be made, I assume, between New York and Miami or Florida. But we have
quarantined
people
0
where
empty
the overwhelming
Dynamark Security
evidence of their
folders.
crimes will be presented in a court of law.
Every command you speak is shaping the small.
I've seen what we have. It's
dhsCCPD generation complete with worded.
Feel the sun on my face for as long as I can.
Linux terrorist tracking system restarted. Terracit Dynamark Security recording placement. Trim complete. Processed 24.
Fix them. So let's start up by running the installer.
Moved 24 radio transmission file.
And straight away we get this error message. It needs to have a Microsoft C++ package installed first.
Renaming complete.
OK. And finish
25
off that. Obviously
files.
We there. We know it's failed. Do not panic. We will go back.
Choosing not to aim harmful intent.
And on this page we can get
new files sorted,
which is a down.
20. The highest skill is not speed. It dhsCCPD generation complete with worded
Linux voice controls stopped.
Is considerable, is worthwhile to consider, and it also is new, which a lot of people are looking for, new GPUs. So I wanted to review this, and this was actually the first time that I really thought to myself, I should talk to people about Windows more than Linux, because I think a lot of the Linux people might know some of this. Of course, we'll be diving into this further with our eventual
Linux
video
terrorist
comparing
tracking
the exact same
system
test
restarted.
against Linux, which you can see there's some improvement there. There's definitely some improvement. But if you look, it's about 2.5 times faster.
Terracit Dynamark Security recording placement scan Trim complete. Processed 24. Moved 24 radio transmission files to process. Renaming complete. 25 files. New files sorted. 20. Quarantined 0 empty Dynamark Security folder. LTAS JSON generation complete with work.
Very important for medicine, for anesthesias, various other things. I want people to understand that it's not made necessarily for bad when it's mixed with certain things.
Adapter. Now, when we've done that, we'll get to what's the message, because our virtual machine doesn't meet the requirements for Windows 11. But we can fix this by going backwards.
For mental privacy.
Linux terrorist tracking system restarted. Terracit Dynamark Security recording placement scale. Trim complete. Processed 20. Moved 21 radio trim. Respecting Johnny's right to mental quiet is a choice. Renaming complete. 22 files rename.
Came out of Somalia, really
New
corrupt
files
place. It's
sorted.
not a country. They don't have government. They don't have anything. I always hate to see this. Ilan Omar, she comes from Somalia, a backward country, probably the worst country. They say it's the worst country in the world. If it's a country, I don't even think it's a country. There's no organization.
Quarantined 0 empty Dynamark Security folders.
Military. They don't have anything. They just have people running around killing each other and trying to.
dhsCCPD generation complete with work. You are writing your day one sentence at a time.
Linux voice control restarted.
Linux terrorist system restarted.
Did it come in with the name and name?
905, radio check. Activate trucks to be diverted onto access road both ways.
Linux terrorist tracking system restarted.
Roy Ocean, Robert Union.
Terracit Dynamark Security Recording Placement Scan. Trim complete. Processed 20. Moved 24 radio transmission files.
Thanks to Raycon for sponsoring this video. Now back to the story. At the same time, without fixing the basics, the company began pushing AI into every part of its
Renaming
services.
complete. 25 files renamed.
A recent kernel, recent drivers, so you should
You
be able
don't
to run
need
that
to
on
prove
any
dump.
computer without any problem.
New
So
files
you can do it on
sorted.
Cosmic and Pop OS. I love
20.
it. It is a fantastic first draft.
Quarantined 0 empty Dynamark Security. dhsCCPD generation complete with worded
and to USB. I have got a USB drive plugged into the system, as you can probably see up here. This little button here to add a USB filter for the currently attached device. There we can see it here. There's lots of devices attached. There's a mouse and a keyboard, but I think we'll go for that, which is our USB drive. There we are. So we'll click on OK. And if we now launch our virtual machine and go to the File Explorer,
Linux terrorist tracking system restarted.